we have an interesting topic to talk about, which is a new thing that is involving what turned out to be legislation in the city about finding about information about old documents. So it's also known as City Council Resolution 560. Ben Chevat from 9/11 Health Watch, Andy Carboy and myself were involved with this, and I'm going to allow Ben and Andy to introduce themselves. Okay?
Sure. Ben Chevat, 9/11 Health Watch again, and
Andy Carboy, and Ben Chevat is our client in this lawsuit we brought against the city.
Yes. So I'm really glad that Mary and Frank had this segment because I think it's calling attention to something that happened over the summer that didn't get enough attention, and I think that's going to be pretty consequential for the 9/11 community. I'm going to just tell a little bit about the background, the journey to get here, and Andy's going to fill in about the FOIA issues, and Matt's going to talk a little bit about some of the concerns the city has. So this started when my old boss, Congresswoman Carolyn Maloney, and Congressman Nadler, in the run-up to the 20th anniversary, sent Mayor de Blasio a letter. And all of this is on 9/11 Health Watch's website on New York City Documents, if you want to read along. And what that letter was to the mayor saying I'm paraphrasing, it's the 20th anniversary. It's now time for the city to sort of release documents as to what the city knew about the dangers of the toxins at Ground Zero, and when did they know it. And again, that's a very paraphrasing version of it. Mayor de Blasio didn't respond. He left office. Mayor Adams came in, who everyone knows is a 9/11 responder himself, having been NYPD captain at the time, and basically sent the same letter. The mayor responded, unlike Mayor de Blasio. He responded and he says, well, I want to, and again, paraphrasing, I want to meet with you and tell you why we can't do this. And as the press reports about that meeting, the city corp council representatives, I wasn't there, came in, and they basically said, we have these documents that talk about what the city knew and when it knew it, but that we don't want to release them unless you get liability protection, more liability protection for the city. And when I saw that, and I talked to the staff that had the meeting, it was kind of, concerning, because it was like they kind of have something, but they don't want to give it out. And it's not like, well, we might have something. So there was several more letters back and forth between the members of Congress. Then Congressman Nadler and then Congressman Goldman followed up. And talking to the board of 9/11 Health Watch and talking with my friends Andy Carboy and Matt McCauley, I said, well, we should do something about this. We should try to highlight this issue, because these are city documents under the law in the state of New York. They're public, and they can't just, whether there's a issue with liability, which Matt will talk about, or not, that's not one of the exclusions that you have under the law. And we brought the action, and I'm going to turn it over to Andy, because that's a story on itself, and then Matt will fill in some of that. So.
Okay, so basically, we knew the congressional delegation had sought these documents. Essentially, these are risk assessments. To Ben's point, what did the city know and when did it know it? Why did the city make the decisions it did? Paramount among them, the decision to reopen the schools. There had to have been risks, right? But the city slanted toward benefit. So I want to take you through the broad categories of documents we requested. Models and estimates of exposures and expected illnesses. Deputy Mayor Robert Harding authored a memo in which it was predicted, this is the fall of 2001, that there would be 10,000 liability claims. Well, why was the city projecting that so early on if it truly believed and understood the air quality to be safe? The decision to reopen the school. What information, what studies were looked at to make that decision? Air testing conducted after the 1993 bombing, we learned from litigation the Port Authority had with its insurance carriers that started back in the 90s. The New York City DEP did air testing in February and March of 1993 and clearly had detected something. It was important enough that the judge in the Port Authority lawsuit, pre-9/11, referenced it in his decision. So we wanted those earlier asbestos air testing records, which would underscore, perhaps, we don't know, the fallacy in proclaiming the air to be safe after the September 11th event. We also sought information concerning the city's lobbying efforts. The city has two sort of obscure offices, the city's Department of Federal Affairs and the Mayor's Office of Intergovernmental Affairs. They have offices in Washington, D.C., and they worked early on in the fall of 2001 to cap or preclude any liability on the part of the city. Matt's going to talk about that in a moment. Well, why was the city doing that if there weren't well-placed concerns, contrary to the messaging? Lastly, after the 1993 attacks, we all heard and read, and it was referenced in the criminal prosecution, the goal of the terrorists was to topple the towers back then. Letting our imaginations run, we presupposed, and we don't know, I want to underscore don't know, that various agencies, it was probably intergovernmental, state, federal, and city, ran simulations before the collapse of the Twin Towers as to what would happen in the event of a collapse because of the 1993 experience. So those were the categories of information. We targeted a number of city agencies, paramount among them the City Department of Environmental Protection, because it took a lead role in the response. Can't get away from that. That's a matter of public record. We also know from having other lawsuits against the city, and I'll just share this with you, the city works to destroy or hide its secrets. After the First Victims Fund closed, I was involved for over 9 years with a lawsuit on behalf of over 700 first responders. The claim was the city failed to provide them with the appropriate respiratory protection. After 7 years, it took that long, we were able to ascertain there were 700 air purifying respirators on hand for the 10,000 members of FDNY that morning. So less than 7% of the appropriate equipment was on hand that day. In 2 lawsuits I've had in the last year, I've had the city sanctioned twice. One for failing to turn over documents. The city was fined $1,000 a day until such time as it did. And in another case, the city defied a preservation order we'd secured before the lawsuit, destroyed evidence anyway, and was sanctioned for that. So it came as no surprise when we got the denials from the city. The denials were essentially, we don't have these documents. The documents were destroyed when 7 World Trade Center collapsed on the afternoon of September 11th, because that's where the Office of Emergency Management was. Now, mind you, we're not talking about documents they made that day. We're talking about documents that predated that day and were generated in the weeks and months afterwards. Finally, the city insisted that we identify with precision the titles of each of these documents, their current whereabouts, and the names of the custodians who have them. That obviously is an impossible task. We appealed the denial internally to these various city agencies, and when those appeals were unsuccessful, we brought our lawsuit in court. We are currently before the Honorable James Kleins in Manhattan. We've kept him abreast of the developments with respect to the City Council resolution. I think it bolsters our claim. And we're seeking a hearing. We're seeking a hearing with live testimony. We want to find out about the diligence that was exercised in responding to our requests. And we want to ask additional questions that would shed light on these denials. So that's the status, in a nutshell.
Of the FOIA. Thank you.
Yeah, sure.
And then Matt, one of the, just So to give Matt sort of the question, and because we don't have a lot of time, I hear you, Frank. The city's concern is, that was stated in these meetings with the congressional members was, well, we need more liability protection. We're worried about these documents. Do you want to talk just a little bit about that?
Sure.
And why we,
The interesting thing about this process was it didn't start out with the intention of, or it still doesn't have the intention of involving litigation, other than the fact that it became litigation. This was not an attempt to reopen anything to do with the first lawsuit that was settled of, 12,000 people back in 2010. It was to get information. When the city responded, they didn't say, oh no, we gave you that already, it's all been turned over. There's nothing that you don't have from the prior litigation, see the 101 or the 100 docket. Their response was, we have documents, but we can't turn them over because we're afraid of liability, that's FOIL 101. You can't actually respond to a request that way. And then it just kept going after that, of not saying, and then we don't have any documents, but if you went on the DEP website, there's actually a picture of them, of DEP on their website at Ground Zero. It just kept going on, and we kept pushing, saying, this is not about litigation, and it's not. This is not about a litigation in a sense of reopening something to bring about more claims, to reopen the original lawsuits. It became a fact-finding mission, which is really what it is, in a sense of, well, as we keep moving forward, this information becomes more important because the science also keeps changing. It keeps getting more advanced. More things keep getting added. For the people who've sat through, the two panels before this, at the same time, this is information that may be relevant to other things that are going on in the World Trade Center Health Program. It may be relevant to other exposures that are out there. And to not be able to get any access to it at all, or be told that it exists, but we're just not going to give it to you because, and that's where we've been. It brought us to litigation. We sat there, this isn't about it. And now here we are in this position to say, okay, well, I guess we have to litigate for it because at the same time, if you're not going to give it to us, then because of a liability issue, that's just not the proper response.
And that leads all up to this past summer, or actually last year. We were finding the city stonewalling, and we just thought, this is 23, 25 years later, what's going on there? I ended up talking to former borough president, Gail Brewer, who's now a councilwoman, about what could we do about this issue. And her staff did some research, and they found out something that wasn't quite well known within it, that the last city charter had created a provision that allowed the city council to order the city's Department of Investigation to do an investigation. And no one had actually used this exercise before. So the councilwoman drafted a resolution, Resolution 560, and with the work of Speaker Adams, over several months, they worked, and over the summer, they passed it. So now the Department of Investigation, which is a pretty sophisticated, though underfunded entity of the city of New York, is actually been ordered to do an investigation to, and again, I'm paraphrasing, what did the city know and when did the city know it? And they have 2 years to come back and give a report. And I think it's just, having gone through this now for 24 years, I can't make judgments about mistakes that were made by the city of New York or, what they did in the response to this terrible day. But had they at some point said to well, maybe we're making a mistake, maybe we should be more careful, a lot of people who are sick would not have gotten sick. Had they made the decision to admit that maybe there was something going on here, and not, because what happened, having been on the receiving end when I worked for Congressman Maloney and with the delegation, we had to fight that the city, the state, and the federal government said there was no danger and there was no impact. And that took time, and we're still doing this, fighting Congress to provide the funding. So I think it was a really important thing. It didn't get the recognition, obviously, when it happens, because what we do know from a New York Times article in 2007 is we have this memo that the city wrote in October of 2001 saying there would be 10,000 toxic claims. And then a few weeks after that, and I was in Congress, working for Congress at the time, the city of New York got a provision put into a bill limiting the city's liability to $350 million. The two are connected. Why were they taking this action so quickly? And again, a prudent action, obviously, but why was this happening? And we're hopefully going to find out within a year or so. So that's basically it. So I don't know. You want to?
Yeah, just a closing thought.
Closing? Yeah.
Yeah, Ben has always said, and I think this is right, sure mistakes were made, but there were some bold decisions made back then that were probably ultimately beneficial. It's a mix. And as disaster relief, and we're hearing this and reading it in the newspaper, becomes less federalized, with federal money now flowing more to local agencies and authorities, this model, this example of the September 11th response becomes extremely important. The future of disaster response to some, and this is probably right, will be more local. And in New York City stepping up when it did, there's certainly important lessons to be gleaned from that.
Yep.
I live in Lower Manhattan at the corner of Bleecker and Thompson Streets. Flight 11 killed my wife, flew right over my building. I'm a pilot, and I knew exactly what kind of plane it was.
I'm sorry.
And in fact, I'm the first guy to call the FBI to tell them it was not an accident. Because I instantly knew it was a twin-engine jet at full throttle. I watched a lot of that stuff. My dad's a chemist, and so it kind of comes into my head. And I'm wondering how much about what the city decided to do on the spot because it had no prior example of what to do. So they kind of, you might say they kind of have to make stuff up as they go without any real experience on what to do. How much of this was based on the federal list of chemicals, harmful chemicals and compounds and so forth, that the federal government created? Because remember that the head of the EPA, what was her name? She was governor of
Christy Todd Whitman.
Christy Todd Whitman, thank you. I mean, they have a list.
Sure.
If it wasn't on the list, it wasn't technically, legally harmful.
Regulated, right.
Yeah, right.
Yeah, yep.
But if you take a look at, you got two towers, a quarter of a mile high each. You got a lot of solid compounds that have been ground up and then burned. Anybody that remembers, if you took college chemistry, you got physical changes, you got chemical changes. How much of that stuff is stuff we never even knew about, that didn't exist?
So
And you get where I'm going on?
So I don't think
point.
I'm not qualified to answer that question. I'm not a toxicologist. I'm not. But all I know is that hopefully we will have some better information about what happened 25 years ago because of the city council's action, and because it should be a knowable thing now, 25 years later, and for the city to take the position to the congressional members that, well, we have these documents, so it's like presence of mind. Do they have a list?
Right.
And we're not going to give it to you unless you give additional protections to the city. It just seems,
Kind of what I'm talking about is how can you be held liable for something that you didn't know would exist or even could exist based on how the whole thing happened?
So that's important you brought that up, because here's the thing. The information we're trying to get in 2025, which does relate to 2001, is to be able to hand that over to somebody with your intelligence to be able to go, okay, this is information that now we look at it in 2025, could have caused cancer, could have caused this, could have been this. That part of it to answer, it's not to point fingers at anybody.
Right.
It's to say, this is what we have now. And there's no doubt that 9/11 illnesses happen. They continue to develop. But to be able to take that information and say, okay, it supports what we know already. Great, there's not going to be anything else. Or it's opening up this door someplace else that we need to look at. What's there?
But it's also to protect. It's
Yes.
to protect against an outside entity, let's leave it at that entity,
Right.
private or public, whatever, coming in and swooping down and want to make a mess of what we never knew to protect from, legally, in a lawsuit type of thing. That needs protection. We didn't know this stuff was going to happen.
Well,
We need a legislature or we need Congress to throw up a wall of protection against this kind of thing, just like they did with the airlines that resulted in the VCF.
yeah, and you might want to consider this too. After the lawsuit settled, after the VCF reopened, okay, with the passage of Zadroga, the Second Circuit Court of Appeals, only the U.S. Supreme Court is higher, upheld the dismissal of a case involving 9/11 response because 9/11, quote, was an act of war, and any response would be given immunity. The city of New York is protected. Its argument that we're seeking to reopen liability is misplaced. The alternative of the VCF, it's not even an alternative. It's the only option for the people everyone in this room is working for. That's my personal view, having done the lawsuits.
All right, thank you.